Now, the media reporting of this has been slightly unusual insofar as Peter Murrell has been named by media outlets at the point of his arrest. This is something that doesn't always happen. So, in an effort to help us understand the legalities behind reporting such a case, I spoke to Sophie Cargill, who is a solicitor at Mellix and an expert in media law and defamation.
There's always a risk when naming someone at arrest that you may not have the right person. The police will give fairly sparse details when a person is arrested. Normally they'll say something like woman 25 arrested in connection with X offence, and they won't provide the full details at that point. They might confirm off the record to press when making inquiries that the person they think it is the correct person. But there is always an extreme risk that you might get the person's identity wrong in reporting. And aside from that, there's also a risk when reporting on any active criminal proceedings that you might prejudice the ultimate trial. And that's what anyone reporting on criminal proceedings seeks to avoid, because the consequences would be dire, not just for the criminal trial, but also for the person who may be found to be in contempt.
Yeah, that's the issue with reporting this. So the audience, maybe quite rightly thinks you can say anything you want and ask any question when these things are happening. But just explain to the audience contempt of court to the listeners when it comes to broadcasters, broadsheets, and even social media. Just explain contempt of court.
So contempt of court applies to everyone in the same way. So it's not just publishers, broadcasters. Those using social media are also bound by the law on contempt of court because it is the law of the UK. And essentially what the law says is that nothing can be published either by, again, a broadsheet newspaper or online and social media accounts, which would prejudice the trial of an accused person. And effectively what that means is that nothing which would risk the trial or risk the accused person being, stated to be guilty before they're found guilty by a jury should be published. And there are a number of things which would cause that risk and which should never be published. For example, suggestions that a person is guilty, reference to previous convictions, or references to bad character of an accused person. All of those things, if put in the public domain, could be said to prejudice the upcoming trial, because a jury reading those things about someone who's about to face trial might have their mind swayed by the information they're seeing before they actually go into their jury deliberations and hear the evidence.
Yeah, because if, let's say, John Beattie's arrested and the presenter says, well, the clearly guilty John Beattie's been arrested, that means, for John Beattie's point of view, it might not be a fair trial. And the police have said this matter is active for the purposes of the Contempt of Court Act 1981, and the public are therefore advised to exercise caution if discussing this on social media. So in terms of our audience and discussing this on social media, what should they know?
I think the audience should simply be careful about what they're saying on social media. And if, for example, they're minded to tweet about this, they should be careful not to suggest guilt, not to add their own spin on things by referencing things that they may know about an accused person, references to their character, etc., which might be said to impact negatively on the accused person. And it is difficult because I think social media users think, well, that doesn't really apply to me. That's really something for newspapers and broadcasters to consider rather than me. And I can say anything I want online. But when it comes to contempt, your audience does have to bear in mind that the law does apply to them too. And great care should be taken to ensure that they're not saying anything which might prejudice an upcoming trial.
So whoever you are, just be careful. Even on social media, yes. Facebook, Twitter, Instagram, don't say stuff that can get you into trouble, that could prejudice the case.
Absolutely. And it's not just a monetary punishment. There can also be a punishment of imprisonment for up to 2 years. Now, that's rarely handed out. And in fact, it's really even threatened. But it's something that you should bear in mind, that if a contempt is particularly bad, it may be that could be the punishment facing anyone that's found guilty of it.
Sophie Cargill from Mellix.